City staff, after having some internal discussions, declined to meet with the engineering team and the applicant team. So the development agreement, the memo from Multi-Tech regarding how to, measure the basins and what part is Phillips Estates, that was with city staff since June 12th. We had hoped to come to terms with them, and that way we would just be able to say, yep, we agree with the proposed order from city. But we don't. So I've got an alternative motion in front of you as part of the packet. And that alternative motion contemplates incorporating the development agreement that I originally provided to the city last month as an exhibit. And, I'd like to be able to say the city manager and the city's, public works staff, they've all reviewed it and they approve it. We don't know. We don't know. They haven't given us that feedback, but the feedback that we did get is they don't want to decide. They don't think that this is the right time in the city's perspective to go ahead and decide to what percentage the city is responsible for mitigating or for sharing in the cost of these public improvements. And I respectfully disagree with that. So when the chair reads the original, opens up a land use hearing, one of the very first things you say is, if you have any concerns regarding an issue, you have to raise it. Don't raise it, you potentially waive that. And that script, even expressly includes issues regarding constitutional takings, which when we're being told in exchange for the right to divide your property into lots, you have to create a public improvement. In this instance, not only is it the property within Tract A that's to be dedicated, whether that goes to the city or an owners association, doesn't matter. But we had to acquire easements offsite. We had to design it. We had to get all the engineering approvals. All of that costs significant resources. And Phillips Estates only generates 25% of the stormwater. So we don't have any more hearings. There's no more phases. So we have to raise these issues. And we did everything we could to try to iron this out beforehand, but that didn't happen. So we're asking you to go ahead and adopt the alternative motion. I think city staff will say, well, you're not the right body to do it. My argument is, well, if you have the power to take property rights from applicants, you have the power to go ahead and decide what percentage is the city's responsibility and what percentage is the property owner's responsibility. And I think even in this instance, I have more problems with this argument about this isn't the right time, because we had an express back and forth with staff during the completeness review process. They insisted that as part of our application, we prepare a development agreement. That wasn't originally included. But they said, no, our code, our criteria requires you provide us a form of the development agreement. So they've had an early version of that from the very beginning of the application. And we've never gotten a single comment on it or any guidance as to what it needs to be. And now the hearings are coming to a close. The record's going to come to a close. So the risk to the property owner is we need some, we need to make these decisions out in the open, because we don't want conflict with the city. We want to capture this construction season, get our approval, and be able to contribute what is our fair share, and then have a plan for a reasonable reimbursement for the city for the portion that is the city's obligation. And so we've done all the engineering work. We put together cost estimates as to what the project costs. We put together a draft development agreement. The first version was included in the original submittal. Upon responding to the incompleteness letter, the last version was provided to the city on June 12th. The only minor updates now are just to date it and fill in some of the blanks. Um, and this is it. Like we need to know, because if the city just issues the decision and they wait till the local appeal period lapses, and they wait until the opportunity for review at LUBA, well, then what if we can't come to reasonable terms? They would be putting us as the applicant in a very unfair, difficult situation where we've got no public process to hear this out and no resort but to sue the city. But at this time, I don't even know if we have a conflict. They haven't said, Mr. Sorum, we're not, we don't believe that you're entitled to reimbursement for anything. Or Mr. Sorum, you're entitled to some, but not on this 75-25% split. So that's why we have to go ahead and prepare everything and submit it. So you've got that cover letter. You've got, so this is the cover letter. You have in your packet some red lines to the proposed motion and final order. And the document's relatively long just because it's the entirety of the proposed order, but the edits to it are very short. Really, they correct one typo on the first page, and then they address two conditions. Condition of approval is number 6, where it talks about that the engineer shall construct the stormwater facilities pursuant to the approved stormwater design. We prefer that language because it's more accurate, it's factually accurate, rather than saying as a future condition that we design the facility. Well, we've already designed it and the design was already approved. So we wanted that language to be reflected in the condition. And then also in section 10, rather than just having a general reference to a future obligation for a development agreement, I attached as an exhibit that my proposed development agreement. And I'm sorry that you're seeing it for the first time, but that's because, well, I don't know why it wasn't included in the record earlier, but it's not, in my opinion, a new document. It's been in the works for some time. So, and then finally is just a memo that puts into written words, the two legal issues that I've spoken at length before. The first is the needed housing issue, which I'm sure you've heard in other cases, but when you are issuing permit decisions regarding like subdivisions over, you have an obligation for those housing applications to have clear and objective standards, but state law also requires that the conditions of approval not be unreasonable in cost or not cause an unreasonable delay. And as an example, we're concerned about two issues there, both the cost and the delay. If we don't have any process to come to terms with the city on finalizing this development agreement, it's just indefinite. If the city continues to move the ball on us, doesn't ever tell us what's an acceptable term of an agreement, well, that could just go on and we lose this construction season, but potentially many others. And since this is phase 3 of something has a history of more than a decade ago, we're very sensitive to that risk of delay. The real estate market demand goes up and down. Just because we have an opportunity now doesn't mean that opportunity will still be there for us in a year. So time is important. And then the cost associated. We know this facility is expensive. We've put in much of the resources already. There's still some construction work that needs to be done. But we've got estimates as to the rest of the costs. We're entitled to be reimbursed for the portions of the stormwater that are being detained associated with other parties' properties. So that would be, to do otherwise would be an unreasonable condition of approval from a cost standpoint. So that's a state law basis. Federal law, constitutional law, is that Nolan Dolan case that you've probably heard about in some trainings. But essentially, it's the city's obligation themselves, not us, but the city, when they're applying conditions of approval, they can only apply conditions of approval that are roughly proportionate. The city is supposed to be doing the proportionality analysis. In this case, they didn't. We went ahead, our engineers prepared a methodology. There's 3 different methods that they evaluated how the stormwater could be measured in the basins. And the consensus is at minimum a 25-75 split, being 25% the responsibility of Phillips Estates. So that's why we're asking for the reimbursement there. The other reimbursement is probably not controversial. It just is regarding the state's SDC program. We upsized a water pipe from 8 inches to 10 inches. We don't get reimbursed for the entire 10 inches. We just get reimbursed for the incremental cost between that. That's SDC eligible, so there should be SDC credits readily available to do that. I don't anticipate that to be an issue. But we are entitled to it. So we did work hard. If you're frustrated, I share your frustration. We've done what we can. I was out all of last week with my family, so I couldn't give you, everything ahead of time, but candidly, I don't know what the city's process for getting you documents ahead of time would be. But nonetheless, much of this that is before you tonight, other than the final memo in my cover letter, is work product that the city's had for a very long time. So I can answer any questions about anything you have in here. Natalie Janey, our stormwater engineer, is also here if you have questions for her regarding how did she calculate the different basin sizes, the proportionality. Happy to get into the details. I know you got an agenda. I know you got things to work through. So that's a competing interest. And I also know that staff's going to say something, and, I would like the opportunity to rebut whatever staff says. So just please keep that in mind. So with that, I want to be sensitive to time, Chair.
At this point, this is coming before us like this tonight. And I don't know I guess I would say they're almost allegations you're making about city staff and their inability, in your perspective, to provide concise decisions back to you on percentages and so forth with the 25-75 or whatever the reimbursements are. That's asking this commission, Commissioner Sims, I'm hearing the city staff. You can chime in too, Jennifer, but what I'm hearing is I don't know if we're doing our job. That's the presentation I'm getting.
Oh, yeah. Well, I don't think that's accurate. They proposed a alternative set of draft order of approval, and they sent it to us with some track changes and comments, and myself and the city attorney and our city engineer went through it, and we changed some of the wording that they suggested, and then we also put comments when we didn't agree. And we submitted that all together July 7th. So it's 27, it's the 27th today. And I thought that that would be likely enough time for them to provide any comments back by a week before when you get your packets in. So one of the things that we said to them in the comments that we did not agree with was developing a developer's agreement, which is what they're proposing here. They do propose a few somewhat minor, 2 other minor changes, but this is the main change, is to include the development agreement, which we told them is not appropriate at this time. So we said that July 7th to them. And I actually have, I spoke with the city attorney this morning, and he did put together a memo. I can read it aloud and then send it to you and the applicant's attorney. I didn't even get a chance to read it all. And this packet you got, I got at 8:30 this morning. So it really didn't give us a lot of time to review. But I'll read what Ross, the city attorney, said. I don't have printouts, but I can definitely email it to Alan. So it says, I'm just going to read it out loud. The Planning Commission is set to consider the master plan development application for Phillips Estates 3. The hearing tonight, July 27th, 2026. This morning, the applicant submitted comments on the staff's proposed order. You asked that I provide input on the applicant's comments as the proposed condition of approval number 10, the applicant's proposal to have a development agreement approved by the Planning Commission as part of the decision. While the development agreement will likely be part of the life cycle of this development as it moves from planning concept to development, it is premature for a final development agreement at this stage. In addition, the Planning Commission is not the approval authority for a development agreement. We only need to look as far as the proposed development agreement's treatments of system development charges, SDCs, to see that a development agreement is premature. The applicant's proposal lists certain public facilities and identifies them as qualified public improvements subject to credits under ORS 22.3.304(4). Contrary to the applicant's proposal, the city's SDC program is governed by SMC Chapter 13.4. This chapter of the code provides the mechanisms for computing SDCs and seeking credits. The Planning Commission does not have the role in the SDC calculation or credit processes. In short, SDCs are not a part of the city's master plan development procedure. A development agreement such as contemplated by the proposed order is a means to secure completion of a required public infrastructure. If the public improvements are not completed prior to other construction activities on the site, or if the improvements involve city financing, a future development agreement will serve as a security for the completion of the public improvements necessary to serve the development. These are technical issues with the purview of the Public Works Director and City Engineer, judging compliance against the city's Public Works Design Standards, CCMC 172470, City Review of Construction Plans, 172120, Financial Security for Improvements, and ORS 195.860, State Standards for Reviewing Final Engineering Plans. For example, there appears to be some disagreement in the record as to the nature of the water facilities that the applicant will need to install. At the very least, it is evident that the final design of the water infrastructure is not set. This disagreement as to the water facility does not jeopardize the current master plan development application, but it does illustrate that it's too early to lock in a development agreement for public facilities. Given the compressed timeline for addressing the applicant's comments submitted the morning of the Planning Commission meeting, the above is not a comprehensive response to the development agreement issue. Nevertheless, it is safe to conclude that it is premature to arrive at a final development agreement for Phillips Estates 3, and the Planning Commission is not equipped to take on that role that code assigns to a Public Works Director and City Engineer related to the future installation of public infrastructure. So I can send that to you, Alan. Let's see. This, um, okay. So if we go through the changes that they suggested, I can talk about them. Obviously, the first change is great. The typo of the property owner. But then the next change that they have is relating to Exhibit A, which is the development agreement. And then it's not page numbered, but the next one is the same. And then the next one is the same, and then again, for multiple places. So let's see. So I was able to talk to the city engineer, and number 6, that they suggest changing the applicant's engineer shall. We had written I don't know if I'm skipping ahead. It's if you look at the order that they so this is their document that they just submitted tonight. If you look under the draft order, if you go to the very end, it says order. It's so these are conditions. If you look at number 6, we had written the applicant's engineer shall design and construct engineered stormwater facilities pursuant to the approved stormwater design and the PWDS and SMC 17.24.40 to accommodate all new and replaced impervious surface in the proposed and existing right-of-way, as well as the future impervious surfaces of all proposed lots, including the proposed walkways within the proposed open space parcel. So the applicant decided to take out design and engineered and put in the approved stormwater design. I'm going to put it up on the screen so you can follow. Here we go, number 6. So I talked to the city engineer, and he believes that it should say the applicant's engineer shall design and construct. He said the application's engineer is not going to construct. That's going to be a contractor, right? So he thinks that it should. This is the city engineer just, suggesting the applicant's engineer shall design and the applicant shall construct a stormwater facility. We might agree with that. And we would agree with putting the city approved stormwater design. We would be able to do that. And for number 8 was with the other change. They said that there is no waiver from DSL, that it's either they say yes or no. The city engineer thought that he agreed with if applicable, but we want written confirmation from DSL that it isn't necessary, so we'd want to write that in. And then the other change was for number 10. This is where we don't agree. We don't agree that it's the time for the city to develop a developer agreement. So from staff, I think that what we submitted in the packet is what we agree with. If the applicant wants to extend this application for another 30 days, and we can look at the edits that they submitted today to give us more time. The city is not trying to take extra long. We just got these, we had said on the 7th of July in our in the draft order that we sent back to the applicant, we said in our notes that we do not agree that this is the time for the development agreement to be figured out. So then they just submitted this today. I'll leave it at that. Sorry, it's so long.
All right, so I don't want to speak for everybody here, but I go back, if I listen to the presentation from the applicant's attorney, there were 2 meetings asked for. Is that what you said?
Yes, on the 12th of June and on the 18th of June, both were canceled essentially the day of or right before.
We couldn't get everyone together. That's what happened. So instead the staff met, and we were able to get an agreement on what conditions we agreed with and what we didn't and why. And then I wrote that up.
Okay. I guess my issue at this point is that if the applicant had requested me to meet with staff and we couldn't get together to meet with them a couple of times, and then we made decisions outside of a meeting with them and sent them to them, and now we're getting information back today contrary to that, and the attorney's saying there are things in here that we can't make decisions on, then we put the planning commission in a position that we can't make decisions at this point if we're not informed about we're making decisions. And I understand your position, and I think I see the city, but I'm a little disappointed that we didn't have face-to-face meeting with the applicant. And to me, that's frustrating on my part. So I don't think we can make a decision tonight. I'm going to throw it out to the rest of the commission.
I'm looking at this Exhibit A.
Chair, may I have one last rebuttal before you do the deliberations, or?
Right? No, we're not going to that yet, but yeah, I'm sorry.
Okay.
Go ahead.
Just a couple of things. I don't have the email on the July 7th, but I'm going to assume that's accurate for the time being. My client and the city manager, and I thought maybe some other staff was going to be there. I don't know that was played out the way, but they met again on the 22nd. But then we thought that the meeting was going to be about the development agreement. Staff wasn't ready. The city manager wasn't ready to talk about it. So yes, we got a response on the 7th of July that said, that development agreement that we demanded you provide to us during your incompleteness response and review, the one that we discussed in the hearing, in the May hearing, we had multiple meetings that were scheduled by city staff to go over it that were only canceled within 24 hours. Then we get this, comment, this isn't the right time. So that wasn't well taken by us. We had hoped, this last conversation last week might do something. So some of the tit for tat on timing, though, it doesn't go to the core of it. It's frustrating for you. I'm sorry. I'm not here to say who's more responsible and why the planning commission is in a difficult situation, but I agree with your assessment that you are in a very difficult situation. But I want to talk to the merits of this issue. The technical, like each and every single term of the development agreement, if the city didn't think that was important, it shouldn't have asked for it, shouldn't have demanded it ahead of time. But at where I firmly disagree with city's council, the city attorney, and I want to make this clear for you all, is to say that the city doesn't have an obligation when it demands a condition of approval requiring expenditures for an acquisition of real estate for public facilities to make a determination whether or not that city's condition of approval is proportionate, roughly proportionate. That's been federal law for over 30 years. This is not me coming up with this. It's the city's burden to do it, and they should have been prepared to do it. So I don't take this Alan's being untimely. I commented 2 months ago the reason why we wanted to have those meetings and the reason why we wanted to go ahead and we felt we needed to do this. I've included the arguments regarding needed housing in my original moments. These are not new issues. So the details of the development agreement, I mean, at a core minimum, you must make a determination on proportionality. So that's where I strongly disagree with legal counsel there. From a timing, we're not in a position to offer up the city more extensions. If I felt that that was going to be fruitful, if another month would go by and we would have an agreement, I would entertain it. But this has not been a very efficient process. And at some point, the city needs to make a decision. So my job tonight was to lay out for you, as best I understand it, the facts and the law and the analysis that I believe is applicable. I ask that you adopt our alternative motion. I will hold no ill will if you find that that is too difficult to be asked. You find yourself in a difficult position. I don't envy you, but I do believe the right decision for the city would be adopt our alternative motion. And if not, we'll deal with the repercussions of that, but we're not prepared to give any more extensions. Is there anything else? Are we good? So thank you for letting me to have that rebuttal.
Thank you.
Can I make a comment? Or is it not time to
Comment
come?
for him or,
No, well, to him too, yes.
well,
Yeah.
so we've got to get to, well, there are questions from the commission. This is a question.
It's a question, yes. I'm looking at your exhibit A and the page where it says the city agrees to the following blah, blah, blah. And then your last page says the city has to pay $625,000. I take that as an offense. I've been trying to be on your thing, on your side all along this time, but I know the history of this property and the lawsuits and everything that's gone by, and to now all of a sudden want the city to come back and pay you back for what you've sued us for in the first place. I'm offensed by that. So that's all I have to say.
Yeah,
It,
this is not really a question. All right.
is if that style is a question, I guess my response to that is the issue with the development agreement with phase 2 was this is the arbitration award. It's in the record. If you look at pages 14 of the arbitration award, it's real clear. The issue in that case was, well, what is the scope of the improvements? And then, was there a breach of the development agreement? And on the topic of, was the city obligated to share in the costs? I'm going to read just a quick excerpt from the development agreement. This is from the arbitration award. This is on page 11. It says, during the years in the lead up to the signing of the June 2013 development agreement, the city and the respondent had extensive discussions about how the planned stormwater detention for the system for Mill Creek would be paid. It was anticipated by all concerned that the ultimate expenses would be shared between the city, respondents, and others who would benefit. It continued on page 13 to talk about the thing with that original development agreement is it expressly said, and I quote, what was originally proposed as phase 3 is a future phase of the development. It should be identified as in bulk as Tract A on the plat for Phase 2. The terms and conditions of development of Tract A will be under a separate development agreement to be negotiated at the time of Tract A is proposed to be replatted into Phase 3. So where the arbitrator ultimately landed on is there was no breach of the original development agreement because the parties expressly agreed to defer the proportionality component to this phase. So yes, you're recalling that there was a lawsuit, but some of the details of that, I think, are lost to memory. And this issue has been a long time coming. And it's always been understood that the city was going to have to pay its fair share of that expenditure. And that it was never the intention of Mr. Martinac to assume all of the costs. And so I understand where your frustration is coming from. A lot of sides feel frustration in this, and this is a lot. But again, this arbitration award, this isn't me putting this in the record tonight. This was put in by city from the very beginning. So we were hoping to handle this and get an approved agreement and not put this in front of you and put this on your shoulders. But that's where we find ourselves. And so, at some point, everybody has to say we've done the best that we could under the circumstances. And I think that's where, from the applicant, speaking for the applicant team, that's where we are. But we do reject the comment that it was always understood that Phillips Estates would go ahead, give the land, acquire new easements, put in all the infrastructure to pay for a facility that is detaining water, 75% of which or more is coming from other subdivisions. And that's untenable. And so the costs are extensive. That in part is due to the fact that there's been such a big gap in between when Phase 2 and 3 came about. We can point fingers as to why the time delays have happened, but I'm not going to get into that. But the core thing of, in every land use case you have, the question of proportionality of conditions of approval, that's part of the fact finder and the quasi-judicial decision in every case. Sorry, I don't want to keep going.
I take back my comments. I shouldn't have. I didn't realize there was a pre-agreement. I didn't have the whole picture, but I still don't think this is the appropriate place for us to do a development agreement here at the Plan Commission.
I appreciate your comment. Thank you.
All right, thank you. So are there any questions, more questions from the commission at this point? Okay. Questions and testimony from the public? Hearing none. I think you've given your summary.
Sorry, I don't know. Should I sit down?
But
I'll just sit in case you call me up.
okay. And then at this point, staff summary.
Yes, thank you. So I just want to talk about the staff not meeting face to face. I think we wanted everything in writing was one thing, and I don't think canceling 24 hours, I think there was some extenuating circumstances. There were a lot of people to be in on that call, and we needed to have city engineer and Ross, and I think somebody was not able to be important to be at that meeting. So I just wanted to clarify that. I believe that the draft ordinance of approval that I submitted to you as the packet fully addresses everything that the city and the applicant at the time was comfortable with. The development agreement, as I mentioned, is not, you can vote on what we approved, and they would have detailed master plan development approval. So, and I think that the issue about the development agreement, it's not like we're not going to the planning commission are not going to decide it, but Public Works will work with the city engineer and the city manager to come up with an appropriate SDC charge and development agreement. At this time, it's not the appropriate place, so it makes sense for me for the planning commission to vote on what was in the packet for the draft order.
Which would approve the site development documents that were provided before.
Exactly.
And then that would put in position for the rest of which we really can't, told is not within our purview to comment and would stay outside of that decision at this point and allow city attorneys to work through that with development. Okay. All right. Thank you for that input. So at this point, I'm going to close the hearing. So for the commissioners, I think we heard what Jennifer put forth, and we have in our packet for approval, which would get the SDC, the site development plan approved. As proposed,
With the conditions.
with conditions attached. And with that said, there's things in here that we just can't adopt legally as a planning commission. So I think in the best effort would be to move forward and approve what we have in front of us at this point in time and let the city work through the rest of it.
Yeah, I'm not sure we have the authority to prove the rest of it. And even if we did, I couldn't approve it without having read it.
Yeah, gone in depth. So get back up here.
So I think it's either we approve the draft order as written by staff or we continue again.
I think we approve. Well, what's the thoughts from commission?
Through the draft order by staff and let them make the modifications.
Yep.
But once she agreed to.
Yep. I think so too. That's my opinion. Any other thoughts? Okay. Then does someone have a motion?
I gotta find it. I move that the State Planning Commission approve the application for the detailed master plan development for 1601 Oriole Street submitted by JCNW, if that's correct, Family LLC, Bill Martinek, land use file number 11-07/24, and adopt the draft order presented by staff.
I'll second.
Motion's been made to approve, adopt the draft order as presented and seconded. All in favor?
Aye.
Aye.
Opposed? Motion carries. Okay. All right. Let's go to the next hearing. Okay, our next business agenda item for tonight is code interpretation on whether offices of physicians, dentists, and other health practitioners uses and are included within the hospital use. And
So this isn't a public hearing.
this is not a hearing.
No.
This is not, yeah, that's what I thought. So I'm looking here, Jennifer, where we're going with that one. I've got so many pages on here. Yeah. So what do we need to do on the code interpretation? I know that we're talking specifically about offices of health practitioners that are on the hospital property, specific up there on the hill. We're not talking about dentist office on the campus. We're not talking about offices outside of that.
So let's see. I didn't provide a motion. I thought I would get your input and then maybe we can more formalize it at the next meeting to provide something, but so that's why there were no motions in there. So I have a request by Paul Hartman from the hospital for a code interpretation. He's requesting that the Planning Commission clarify whether physicians' offices included in the use classification are included within the hospital use. The question arises because the definition of hospital states that a hospital may include outpatient clinics, administrative offices, and medical offices. However, the zoning table identifies a separate use of offices of physicians, dentists, and other health practitioners as a separate land use, which is not allowed in the public, semi-public zone. So you're probably like wondering, why is this an issue? Well, the general hospital is zoned P. And there's only a very limited amount of uses in P, usually churches, schools, the hospital, and public owned property like the city hall and the parks. So the hospital does own some other parcels that are zoned other things like commercial, retail, and residential as well. So I think Paul was coming to planning to think about maybe rezoning those to public. And we've always, not just myself, but like the city manager and other planners say that we consider doctor's offices as long as they're part of the hospital, or maybe they're owned by, and maybe this is what we can talk about, they would be allowed under that hospital use. But yeah, but I guess there's discussion to have.
If we're talking, let's use Sublimity as an example. Because isn't there a Sanium Hospital facility in the city of Sublimity? It's not on the hospital property. Exactly. So because if we're talking, when you said properties, they own other properties around the area. They have other properties around the area that function in support of the hospital. And so I guess my question, how are they zoned? That would.
I don't know what the sublimity is.
It's in Sublimity.
Yeah, it's a different one.
It's not us, I agree. Yeah.
Designation in their zoning. It's confusing when we go to the city of Stayton because we have a past when Dan Fleischman was here. He suggested that we would do commercial, which we did. And then we were trying to group all of our properties up on the hill so that we would have just one zone.
Yep.
That zone, we had public or private.
Mhm.
And since then, we purchased a couple of other properties following this plan, which is residential, or it was residential, furniture property, which is residential.
Cross.
We have commercial property down there. Goodwin House, residential.
Yep.
We'd like to group them all into this private, for public use, so that we can use it for a doctor's office and hospital. So when we say commercial, it opens a whole can of worms, everything from 7-Eleven to doctor's office.
So you're talking specifically about the residential properties across 10th Street, the Goodman House, those properties there. Now, what about, then you're not including the parking down below? Oh, that's commercial, okay.
So maybe Paul should come up for the record and call. That's okay. I didn't want to cut you off there. So there's a couple things to remember about public. The The public zone has no design standards. It's like the most flexible. So residential, even single family homes have design standards here in Stayton. Commercial, industrial, all have design standards. Public is the only thing that doesn't. In terms of parking, parking is determined for hospital differently than commercial and especially differently than a doctor's office. So if we were to change, if it were to change to public, I mean, this is what we can discuss later with a zone change, but it's good to understand what this interpretation means. Doctor's offices probably demand the most parking. It's about 5.5 parking spots per 1,000. And the hospital, I believe, is, I think I have it written down. It's a certain amount per bed and certain amount per outpatient. So you wouldn't have as extensive parking as allowed, as demanded if it was commercial. Mhm.
So I guess the question before us then is what would the city, under its zoning requirements, in hospital or in property that's owned by the hospital and functions in support of the hospital, what portion or if all of that gets coded as P, public property, under one assessment? I think that's the question before us. Mhm.
Now, are all the offices on top of Hospital Hill owned by the hospital now?
Yes, sir.
So all the private doctors' offices have all been purchased by the hospital?
Yes, sir.
Okay.
In the past, we did have, the, used to call the Sims Bond and Gooch building was obviously a privately owned. We purchased that. We also, several years back, family practitioners usually own their own clinics, since probably 2015. In that era, we started, bringing those people in as employees.
Okay.
So we purchased their practice and now they're employed through the hospital.
To clarify, so they are associated or affiliated with the hospital in some way?
Yes, sir. They are
Okay,
actual employees. We purchased their property. We purchased their practices. We purchased their medical records, and now they work as an employee of the hospital. Since about 2015.
So the new office that's being remodeled up there, that used to be Jaeger's office, whoever it was, that now,
The LaVenture Clinic is going to be a women's clinic.
Women's clinic.
and that's owned by the hospital now?
Yes.
Okay.
So I guess question I've got is, I understand all the contiguous property that's parking and other facilities are part of that P, but we've got a parking lot that's down at the bottom of 10th Street that is not contiguous to hospital property.
It actually is contiguous.
I guess
Other-
it is if you
other-
get the residences on the hill, or is it?
We own those also.
Yeah, that's what I meant.
Uh,
So,
The only thing that divides our main campus and those three sets of property is 10th.
is 10th Street, yeah. So it's really, could be considered all one campus.
So
Yeah.
I think that's the issue, is defining when it would be allowed. I think we all agree that a doctor's office on the hospital campus is part of a hospital, but then strangely, the hospital could own a property much further away and have a doctor's office, and then it's like zoned differently than another doctor's office, but you might want to allow the doctor's offices as long as it's continuous or like across the street.
That's my thought process. Everything that's on the other side of 10th Street, the residents that are now off space, which touches the parking lot down at the bottom of the hill, which is parking for employees, and the campus itself, my impression would be one contiguous piece, which would be hospital.
Yeah.
That's my thought process. So
And that's what I intend to try to do, is zone that all.
that's how I take it. So that's where maybe the city should take a look at that and see what we can potentially come up with.
So I can write up something and I can bring it back next month and you could do it.
That works. All right, thank you.
Thank you.
All right. Next, public hearing. I'm going to read the statement. Good evening. My name is Larry McKinley. I'm the chairperson for the State and Planning Commission. I will be presiding over this hearing. This is the time and place set for the public hearing in the matter of land use file number 8-05/26. An application for site plan review to construct a 10,239 square foot gymnasium on Regis High School campus located at 550 West Regis Street. The 31.37 acre property consists of 2 parcels and is zoned public/semi-public P. This hearing is now open. Oregon land use law requires a statement be made to those in attendance that covers certain matters related to this case. The statement with all the information required to be presented under ORS 197-797 Bowleg 5 is printed and available at the back counter. If anyone has any questions regarding anything on the statement or objects to it not being read out loud, please raise those questions when it comes to your turn to speak during the hearing. Also at the back counter is the agenda for this evening's meeting, which lays out the order in which people will be called on to speak during the public hearing. The Planning Commission's rules and procedures for land use public hearings and handout written to facilitate your participation in the public hearing. You're encouraged to obtain and read a copy of these documents as well. At this time, I'd like to ask the audience if there are any objections to the notice that was sent in this case. Hearing none. To the jurisdiction of this body to hear and consider this case. Hearing none. Are there any declarations of conflict of interest, ex parte, contact, or bias by any members of this body? Hearing none. We are now ready for the staff introduction.
Okay, so the application before you is a site plan review for Regis Catholic High School, located at 550 West Regis Street. The applicant is proposing to construct a 10,239 square foot practice gym on the existing school campus. And the property is approximately 31.4 acres and is zoned public. So staff reviewed the application along with the city engineer and the city's transportation consultant and Stayton Fire District, and no comments were received, public comments, that is, prior to the hearing. There's 2 existing site conditions that do not meet the current standards, the existing driveway and interior landscaping. So that is written in the draft order. Let me just look up where I mentioned this. So part of the draft order says the commission finds that the proposed practice gym is not substantial alteration for the cost of realigning the driveway or changing the parking. So those were some findings. I just wanted to make you aware that those were included. Staff recommended, also said that there are currently 4 ADA accessible parking spaces and the code requires 6. And there's also a required 20 bicycle parking spaces. And I wrote up this staff report and sent it to them as required 7 days before, and they've already submitted a new plan with 6 ADA spots and 20 bicycle parking. So I've gotten that already. That's great. The remaining proposed conditions continue to ensure that updated plans are incorporated into final approval. The conditions also address final stormwater analysis improvements, water sanitary connections, repair and placement of sidewalk panels that have been identified on the plan, and permits and approvals required before construction occupancy. So based on these findings, proposed conditions, staff recommends the adoption of the draft order. Approval. I'm not sure
Is
here.
there anybody? Yeah, I'm sorry,
Yeah, I'm not sure who's here to
An
speak
applicant
to
here?
this applicant.
please. Please state your full name and your address when you're at the count. You need to punch the button.
My name is Gretchen Stone. I'm with CB2 Architects. The address is 500 Liberty Street, Southeast Salem, Oregon, 97301. We're the CB2 is the consulting architect on the project. I believe Levi Werner is is attending via Zoom. He's the civil engineer with Sandy Paving. At any rate, it's a fairly small project in the scheme of things. Regis has, I think, long been in need of some additional facilities for their programs or existing programs. So this project is literally just to build a practice or auxiliary gym. They're not adding classroom space. It's not intended to allow them to increase student population above what they can already accommodate. And aside from those existing non-compliant conditions, there's no request to deviate from land use standards that would apply to the new building. And there's no, other than correcting the accessible parking to make sure that they meet the standard. There's no real intent to change any of the existing parking other than that. And then we did add 11. There are actually 9 existing bicycle parking spaces. They weren't clearly identified on the drawing, so I can understand why staff was asking for that. But we did add 11 more spaces, actually just adjacent to the existing school building. I think that's it. So unless there's questions for me or Levi.
So less question, just a statement for the commission. So if I understand, the location of this practice gymnasium is basically directly behind the dome, which I would call the dome at Regis, which if you were sitting on Regis Street, you'd have a pretty hard time even seeing the practice zone from Regis Street. So, and it's on the property, it's public property, and anyway, just a general statement. Okay. I have no other
That's
questions
correct,
unless somebody else does. What?
I just have one question. They talk about it not having any additional traffic flow, yet part of it says it's so that you can have 2 times practicing at once. So if you're going to double the number of teams practicing at a specific time, won't that have an increase in traffic?
Well, it shouldn't increase traffic because those teams are already practicing. They just have to
At
stagger.
the same time?
Yep.
So they're not necessarily practicing at the same time, but they're still on campus. Most of the time you're practicing right after school. So if you're having to share gym time, you have students that are having to essentially hang out until their practice time begins in most cases. But those are all existing students as well. So they're not increasing student population by building this proposed gym.
Okay, thank you.
Any other questions from the commission? Very good. All right. So are there any questions and testimony from the public? Hearing none. Are you done? Do you need a summary or are you good with
Nope,
what you
I'm
get?
just gonna leave in case somebody wanted to come.
Okay, very good. Staff summary?
I don't have anything else.
Then I am going to close this hearing. Deliberation from the commission? Any deliberation? I think this is pretty much a good thing to have happen for Regis School Complex. So at this point, I would entertain a motion.
I will move that the planning commission approve the application for site plan review for Regis High School land use filed number 8-05/26, adopting the draft order of conditional approval as presented by staff.
I'll second it.
Good. All in favor?
Aye.
Motion carries. All right, thank you. Our last hearing for this evening. And just a general comment, the commission's decision may be appealed at state and city council within 14 days of the mailing of the notice of decision in accordance with section 17.12-110 of the state municipal code. All right, our final hearing for the night. I'm going to go through this again. Good evening. My name is Larry McKinley. I'm the chairperson for the State and Planning Commission. I will be presiding over this hearing. This is the time and place set for the public hearing in the matter of land use file number 3-03/26, an application for preliminary partition plan for a 0.43 acre lot to divide it into two parcels. Parcel 1, 9,351 square feet, and parcel 2, 9,345 square feet, located at 395 North Noble Avenue and is zoned medium density residential. This hearing is now open. Oregon land use law requires a statement be made to those in attendance that covers certain matters relative to this case. That statement, with all the information required to be presented under ORS 197.797 Bowleg 5, is printed and available at the back counter. If anyone has any questions regarding anything on the statement or objects to it not being read out loud, please raise those questions when it comes to your turn to speak during the hearing. Also at the back counter is the agenda for this evening's meeting, which lays out the order in which people will be called on to speak during the public hearing, the Planning Commission's rules of procedure for land use public hearings, and a handout written to facilitate your participation in the public hearing. You are encouraged to obtain and read a copy of these documents as well. At this time, I would like to ask the audience if there are any objections to the notice that was sent in this case. Hearing none. To the jurisdiction of this body to hear and consider the case. Hearing none. Are there any declarations of conflict, interest, ex parte contact, or bias by any members of this party? All right. This is not ex parte, but my granddaughter dates one of the Jameses, but I have no reason to say I can't make a fair and impartial decision. All right, just to clear that. Okay, we are now ready for the staff report.
Okay. All right. The application before you is a preliminary partition plan to divide a vacant 0.43 acre property at 395 North Noble Avenue into two parcels. One parcel would contain 9,351 square feet, and the parcel 2 would be approximately 9,345 square feet. And the property is zoned in medium density residential. The applicant has indicated they'd like to construct two duplexes on each parcel, just one on each parcel. However, the application for commission is just for the proposed partition. The property is approximately 150 feet frontage along North Noble. The street is not currently improved to local city standards along the property frontage. The proposed conditions require a dedication of a 35-foot width half-street right-of-way and construction of a 17-foot wide half-street improvement, including curb, sidewalk, street lighting, street trees. In addition, the applicant would be required to dedicate additional 5-foot wide right-of-way area, which is slightly reduce the overall square footage, resulting in slightly smaller lots, but this parcels will still maintain the overall required 7,000 square feet. So if you read the draft order, our local roads are supposed to have 60 feet of right of way. This only has 50 feet. So we're going to be asking them to give 5 feet more right of way from their property. So it'd be slightly less than what they're proposing square footage wise. And then we require a 10-foot wide public utility easement to be dedicated along the frontage. So I think, and we just have our standard conditions of approval that address future water sanitary service, stormwater improvements. And the conditions will require that existing trees be maintained to the greatest extent practicable. Comments were received from city engineer and the city transportation consultant and were reflected in the draft order. The fire district had no comments and no public comments were received prior to the hearing. So based on these findings and proposed conditions, staff recommends approval of the preliminary partition and the adoption of the draft order of conditional approval as presented.
Applicant, any presentation from the applicant? Please. Please state your name and your address when you start. Yes, please. Okay. Go ahead. Presentation? Yep. Yep. All right. Are there any questions from the commission? It's on Noble. We know where that is. Okay, so any questions or testimony from the public? Hearing none. I've already heard, I think we've heard your summary. Is there a staff summary?
No, I'll just add, it would be great to see some development on that vacant property. There's been a lot of issues with it being vacant, that people leave some things there.
Yep.
So
Agreed. Thank you. All right, at that point, I'm going to close the hearing. Or is there any deliberation from the commission?
Just
Touch a button, touch a button.
Looking at the site plan, it's confusing in that it talks about lot 6, lot 7, and lot 8 and being turned into parcel 1 and parcel 2. So had it already been divided into 3 lots?
Kramer Edition, which I live in,
Yeah.
they were all divided into 50-foot lots. It's like my property I live on is 2 lots.
Yeah.
And so what they're doing is they're taking 2 lots and 3 lots and making 2 of them. So it's just a matter of reconfiguring it.
So, but they're not currently legally defined as 3 lots.
They are currently
Yeah.
divided. We're taking the 3 lots and making 2 lots.
I think at one point it must have merged because it's only one lot now,
One lot
but
now, yeah.
Okay.
it-
That was my confusion.
Okay,
I guess you're right.
Okay.
My lot is 2 lots, but it's 1 lot, but it's 2.
Okay.
all right. Very good. Any other deliberation? Do we have a motion?
I move the planning commission approve the application for preliminary partition plan for James Baxter and Michael Flanagan at 395 North Noble Avenue, land use file number 3-03/26, and adopt the draft order presented by staff.
Second?
Second.
All in favor?
Aye.
Opposed? Motion carries. You're good. All right, is there any other agenda items for the commission?
No, and I just want to say I'm normally just going to be limiting it to 3 applications, no,
Okay.
no 4.
Very good. All right, thank you. All right, we are adjourned.